Should you trademark and copyright your IP? Like any good lawyer, my answer is it depends. And in this case, it depends on what you're trying to protect and how, because trademarks and copyrights don't protect the same things and not in the same ways. But in other cases, a trademark and a copyright can apply and might help you to double your protections. So a trademark protects your brand identity. These are things that help people recognize your business as the source of a product or service. So examples of your brand identity include things like your business names, your taglines, your logos, your product packaging. On the other hand, copyrights protect original expressions of artistry or expertise. So when we think about copyrights, we're thinking about things like books, photographs, online courses, video recordings, audio recordings, logos, product packaging, fashion design. But hint, hint, wink, wink, what two things did I say twice that apply to both trademarks and copyrights? Logos and product packaging. These things can both tell people who the company is behind a product or service, but they also incorporate certain essential design components that are just beautiful to look at sometimes. But they don't protect them in the same ways. There are certain protections that apply to a copyright that don't apply to a trademark and vice versa. So for example, a copyright has a definite expiration date. It's a long one, but it's a definite one. In contrast, trademarks don't expire. They can be renewed forever and ever into eternity. On the other hand, a huge plus about having a copyright is that if someone does infringe on your work, there are certain default rules that kick in which allow you to recover money from these people. Lawyers call this kind of money award damages, and with copyright infringement, there are certain automatic damages you get when somebody infringes on your work. And it doesn't matter if the harm caused to you and your business is not equal to the amount of the automatic damages that you get. But with trademarks, in contrast, you do have to prove that you were harmed up to a certain amount in order to recover monetary damages from anyone who infringes on your brand. So you see how complicated this stuff can be, right? This is why I tell folks that when it comes to intellectual property, I do not recommend a DIY approach. It's just too complicated. You will be much better served by having an intellectual property attorney who knows your business inside and out, that can give you strategic guidance about how to protect yourself and also how to enforce your rights. I'm Faith Mitten, and simplifying legal stuff is what I do. Follow me, boo.